in a case in which it was reported that you shot a man in the face.
In New Mexico, on March 25, 2018, Crystal Cardenas, consumed by a relationship altercation, stained her hands with the blood of her boyfriend and his current girlfriend. Every crime has motives, but some criminals may genuinely not understand why they committed such heinous acts, or they may fake ignorance.
Or desire whatsoever to kill Mario Cabral.
No, I didn't.
How about Vanessa?
No, I didn't.
Okay.
I was just shocked. I was shocked. I didn't believe it.
How was your mood?
Excuse me?
How was your mood about learning that information?
I started crying.
Even as the criminal pleads their weakness, the bereaved family's cry for justice leaves no room for mercy.
She had told me that if I wasn't able to finish the job, or for some reason it wasn't able to get done when it was going to get done, that Luis was going to take care of it.
Where's the DNA? If she held that gun, where's her DNA at? If she loaded into the clip, the evidence will show you there's nothing comes back on.
Crystal Cardenas, 34, will spend 54 years behind bars. Jesse Kurczewski was sentenced to life in prison for first-degree intentional homicide in connection with the 2018 death of Lynn Hernan. Prosecutors say the two women were friends, but Kurczewski poisoned 62-year-old Hernan over time and stole nearly $300,000 from her. At her sentencing, Kurczewski shared a letter she claimed the victim wrote, admitting to poisoning herself.
Using this on my own terms and how I see fit. No one played any part in this decision or acted in it. I have chose to drink Visine to end my life.
The judge was not convinced.
There's no way Lynn Hernan wrote those. Were you Lynn Hernan?
Hernan's family and friends were in court to give their impact statements.
It's pure evil.
She was more than just a statistic, more than just a name in a news headline. She was a beloved friend, a cherished family member, a bright light extinguished far too soon.
Kurczewski will be eligible for parole after 30 years. Her attorney has reportedly said he plans to appeal the sentence. This monster is hearing the words of the little girl he abducted. In a hushed courtroom, the prosecutor reads a heart-wrenching statement written by the young victim.
Because of you, I can't sleep at night. Why did you do what you did? Did something happen to make you do this? It bothers me that you took advantage of me being nice.
The little girl was riding her bike in an upstate New York campground last September when she decided to take one more loop. That's when she went missing. The search at Morrow State Park, outside Albany, gained national attention after the kidnapper delivered a ransom note to the family's mailbox, demanding $50,000. Fingerprints on the note led authorities to 47-year-old Craig Ross Jr. She was found in his camper, imprisoned inside a cabinet. Her simple yet powerful words were directed at her kidnapper during his sentencing.
You were haunting my thoughts, but now I will be haunting yours. Eventually, I might forget you, but you won't forget me.
Karen Hagan is the district attorney.
He sat there with not any kind of emotion or response, which was disheartening.
The girl's aunt was in court when the statement was read.
What was it like in court to hear the words from your niece?
You know, for a 9-year-old to be so articulate and eloquent with her words, and you could tell that it was a child that wrote it, but it was so thoughtful.
Her mother tearfully read a statement as well.
Don't understand why people like you do the things you do.
A judge had some harsh words and issued jail time for a former sheriff who was accused of breaking the law.
Not above the law.
Former Clark County, Indiana Sheriff Jamie Noel is awaiting trial on 25 felony charges related to tax fraud and misappropriation of funds for personal use. He has pleaded not guilty to the charges. As part of the case, Noel was ordered to surrender all his weapons except for one shotgun. However, the judge stated that additional firearms were found in his home. As a result, he was called before the judge and found in contempt of court.
It's an appropriate sanction. You know what I think the answer is?
60 days in. That's what I think the answer is today.
The judge ordered 60 days in jail, referencing the series in which Noel was heavily featured.
I didn't think it was cute.
Noel's defense attorney argued that Noel made an honest mistake while directing 2 other people to round up all the guns in his home. However, the judge did not find the former sheriff's actions amusing.
I told Mr. Noel, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences.
He was handcuffed and taken into custody today. On November 22nd, 2016, Titus Lee's fiery rage unleashed a spree of kidnapping, robbery, and assault in Philadelphia. We have to wonder what shadows haunt a young mind to produce such horrors. In court, sins are not forgiven. One must compensate for their actions.
The defendant being in prison for a minimum of 240 months, maximum 348 months in the custody of the North Carolina Division of Adult Corrections and Youth Justice.
I would like you to know that the man sitting in that seat over there is responsible for my life being significantly harder than it was ever supposed to be. My innocence is now gone. I found myself harboring feelings of uncertainty and fear just by doing small things like going to the store or meeting a friend for dinner. Things that are supposed to be easier now are hard because I'm constantly looking over my shoulder, expecting a man like him to be mine.
Titus Lee was sentenced to 26 to 182 years in prison. Anthony Tolson, a young father and popular musician, was murdered in Detroit on Christmas Eve. Police quickly apprehended the suspects, who were later brought to court for a preliminary hearing. However, the judge swiftly removed them due to their disturbing behavior.
Members of the media observed while filming Mr. Young was talking and appeared to be making statements to the witness that I was not able to make out the words that Mr. Young was saying. However, it appeared that they were not pleasant words, and his facial expressions were angry, and it appeared to me to be very menacing.
This is 18-year-old Darnell Young and 33-year-old Charles Cox, both in jail jumpsuits, listening to witness testimony during their preliminary hearing. Police say the 2 carjacked and killed musician Anthony Tolson on Christmas Eve outside a party store in Detroit. Tolson had just left Central Baptist Church, where he played bass in a holiday service, and was on his way home to open gifts with his kids, but never made it there. Shortly after, the judge ordered both Young and Cox to be escorted out of the courtroom. As they left, Young could be heard cursing. The judge noted that while Young's words were unclear, they seemed menacing. Both men faced several charges, including murder, carjacking, and armed robbery. If convicted, they could spend the rest of their lives in prison. After a robbery and a murder, you might think Deshawn Boin and Robert Lee G would accept their sentences gracefully. You'd be wrong. Deshawn and Robert were charged with carjacking and first-degree felony murder. Around 1 a.m. on June 26, 2014, Jacob Rameau and his brother Christopher Hotz were leaving a pub in Muskegon, Michigan. When Christopher watched in shock as someone drove off in his 1991 Dodge, Jacob immediately hopped on his Harley and chased after the car. He soon closed in on the vehicle, unaware that the car thief was not working alone until shots rang out from the car behind him. A Muskegon Heights officer later found Jacob's body in a front yard with his motorcycle lying nearby. A week later, the 4 culprits were behind bars: Robert Lee G, Deshawn Boin, and 2 of their friends. While Robert and Deshawn stayed silent, their friends talked. They identified Robert as the trigger man and Deshawn as the carjacker. Robert's case went to trial first. The judge had barely read the guilty verdict when his sister let out a blood-curdling scream. Her screeches echoed down the hall as an officer dragged her out of the courtroom. The judge continued reading the sentencing, but paused minutes later because Robert had passed out, and deputies had to carry him out. A week later, the judge handed Robert a sentence of life imprisonment. Surprisingly, an upbeat Robert appeared unbothered, even blowing a kiss to his family. As for his co-conspirator Deshawn, he pleaded no contest to the charge of unlawfully driving away in an automobile and received a 3 to 10-year sentence in state prison, a sentence that shocked the victim's family. His rambling apology did nothing to ease their pain. Deshawn walked away thinking he'd gotten a slap on the wrist. However, the prosecution had more up their sleeves. A few months later, Deshawn was in a Muskegon County courtroom for a probable cause hearing for felony murder. The prosecution argued that Deshawn's choice to steal the car had led to Jacob's murder and that he was just as responsible. Deshawn was upset. He swore at one of the witnesses on the stand, calling him a liar. Officers immediately bundled him out of the court. Minutes later, Deshawn was brought back in to listen to the judge's ruling. The judge agreed that there was enough probable cause to proceed with a murder trial. Deshawn abruptly stood up and walked forward. The officers immediately returned him to his seat, but Deshawn turned to the victim's family and swore at them. He later sat and went quiet but kept glaring at them. One of the family members yelled at him, and Deshawn lost it.
Bro, stop looking at me, bro. Turn around. Bro, I'm not playing. Look at me.
He continued to swear as court officers led him out of the courtroom. A member of the audience made sure to get the last dig in. Deshawn was later found guilty and sentenced to life in prison without the possibility of parole. Back on June 23, 2013, in Nashville, Brandon Banks was involved in inappropriate behavior with a 21-year-old female student who was unconscious at the time. The jury, which plays a crucial role in the legal system, decided after carefully considering and understanding all the case details.
All right, please be seated. Mr. Foreperson, have you reached the verdict?
Yes, sir.
Would you please stand and read your verdict?
As to count one, we found the defendant not guilty. As to count two, we found the defendant not guilty. As to count three, aggravated, we found the defendant guilty. As to count four, we found the defendant not guilty. As to count five, we found the defendant not guilty. As to count six, aggravated battery, we found the defendant guilty. And as to count seven, we found the defendant not guilty.
And is that your considered verdict?
Yes, sir, it is.
All right, you may be seated. I'm going to ask each of you, with respect to counts 3 and count 7, if that is your considered verdict. Juror number 1, is that your considered? 3 and 6. Thank you. Juror number 1, is that your considered verdict? Yes. Juror number 2, is that your considered verdict? Juror number 3, is that your considered verdict? Yes, sir. Juror number 4, is that your considered verdict? Juror number 5, is that your considered verdict? Yes, sir. And juror number 7, is that your considered verdict? Juror number 14, is that your considered verdict? Yes, sir. Juror number 13, is that your considered verdict? Juror number 12, is that your considered verdict? Juror number 10, is that your considered verdict? And juror number 8, is that your considered verdict? All right, thank you all very, very much. I do want to speak with you very briefly. Anything from either side? All right, thank you. You are excused. I do want to speak with you very briefly. Thank you so very much.
All rise.
In court, one of the toughest jobs is determining the suspect's fate, and that's the judge's responsibility. In this instance, the judge carried out this duty.
Thank you both, and thank all of you who have testified, as well as I want to give my appreciation for the victim's impact statement. Well, as you all know, I've sat through 4 trials. I've lived through this experience for the last 4+ years now. And I'm very familiar with all of the facts and have a fairly good perception of all of the individuals involved in this matter. As I've stated before, the defendants in this particular case are not your typical defendants. Most defendants who come before me have a different kind of background, have prior criminal records, and oftentimes by the time they get to sentencing, not only do they have prior records, they have the records that they have accumulated between the time that they were charged with the original offense and they're being sentenced for that offense. In this case, of course, Mr. Banks just has the offenses that he was charged with and convicted of. He has no prior record. I have looked at the enhancement and mitigating factors in this case, as I always do. And I try to look at the entire individual and listen to those who support him, as well as those who are not in support of him or her, as the case may be. So I don't think there's much more that I need to say about it. I believe that the proper sentence is 15 years for count 3, 8 years for count 6, and he will have to deal with offender registry matter the rest of his life. That's the judgment of the court. And that will be concurrent, of course.
All rise.
On the morning of November 20th, 2016, Detective Benjamin Marconi, a 20-year veteran of the San Antonio Police Department, was sitting in his patrol car in front of police headquarters, checking the information of a driver he had pulled over. Suddenly, a black car pulled up behind his cruiser, and a man got out. He ran to the officer's window with a gun, opened fire, and then quickly fled the scene. Emergency calls went out, and officers rushed to the scene. Unfortunately, it was too late for Detective Benjamin, who died at the hospital. The police released images of the suspect's car and footage of the same man at police headquarters just hours before the shooting. A massive search ensued, and the police did everything they could to catch the killer. By the next day, they had identified the shooter as 31-year-old Otis McKane. While the police searched for him, Otis went to the Bexar County Courthouse to get married. Eventually, the police found him and kept a close watch, waiting for the right moment to make an arrest. 30 hours after the shooting, a SWAT team moved in on Otis as he drove along the interstate in a white sedan. He was arrested without incident. As shocking as his actions were after the cold and calculated murder, everyone was puzzled about why he targeted the detective. Otis claimed he was angry with the court system for not allowing him to see his son during a custody battle. However, the officers who brought him in reported that Otis had told them a completely different story.
Statements, which was, glad that I shot him. You can't judge me. Says I felt good to do what I did. And I finally got somebody to listen.
I'm doing okay besides the fact that people think I killed the police officer.
He claimed someone was impersonating him and even portrayed himself as a victim.
I've been falsely accused, or they accused me of a situation that I refuse to talk about.
Otis was charged with capital murder and faced the death penalty. After several delays, his trial finally began. Witness after witness took the stand, describing the shooting in detail.
It's something, but whenever I saw him, he went like that, and he kept going back to the car.
Tell the jury why you picked picture number 3 and signed and dated it.
Because I was 80% sure that was the gentleman that I saw running towards the patrol vehicle.
We had to try to do something quickly, so I had turned his head to the side to pour the blood out of his mouth to try and help establish an airway.
I didn't know who it was, but it's just, I know it's one of us.
Once you saw who it was, what did you then do?
I ran out and I started telling everybody because nobody knew who he was.
One witness, a crime scene technician, presented evidence from the horrific scene. 2 videos were shown in the courtroom. One video captured the moment Otis shot the detective, and it was so brutal that a juror threw up on the spot. In the other video, Otis admitted to the shooting during an interrogation.
I apologize, that was the stupidest thing I've ever done in my life.
As he watched the video, Otis wiped tears from his face, one of the few times he showed emotion in the courtroom. The defense spent only 25 minutes making their case, the same amount of time the jury took to return with a guilty verdict. At first, Otis seemed indifferent, but soon he began unbuttoning his shirt. Once the jury left the courtroom, Otis sat down and placed his head in his hands. When the bailiff approached to lead him out, Otis stood up and attacked the bailiff with his elbow. 3 officers quickly tackled him to the ground, and several more rushed to assist. There's no telling what else happened behind those doors, but Otis was on his best behavior at his sentencing the following week. Detective Benjamin's daughter addressed her father's killer for the first time.
I always thought of myself as a strong person, but since then, it feels like I have to be stronger because he was such a strong person, and I want that to stay alive.
Otis stared ahead, possibly recalling his one prayer.
I can pray for him, but I don't care to do it.
Unfortunately, for Otis, that was exactly what he received. He was sentenced to death. Otis kept his composure this time and was led out of the courtroom without incident. After deliberating for 3 hours and 26 minutes, a jury composed of 7 women and 5 men reached a guilty verdict in the trial of 35-year-old Veron Primus of Vermont for the November 2015 killing of 33-year-old real estate agent Charlene Greaves. The prosecution, led by Kareem Nelson, presented the case.
Another girl in the United States.
Yeah.
He said that?
I don't know why. I would like to know the reason why. But I feel good because he's found guilty.
The very day Charlene she was threatened in the morning by people.
But just one thing, I still don't know why. Still don't know why.
The police found his jean pants full of.
He used to threaten me a lot. Like when we got into like arguments and things, he would threaten me with knives. I need to find out the reason why. And I need justice for my daughter. That's why I come here.
An assistant director of public prosecution, along with Crown Counsels Kaylee Anthony and Jean Bala, presented a case where one of Primus's adult female relatives, with whom he had a consensual relationship, testified that he confessed to killing Greaves. Primus was also wanted in New York, as he had been indicted in June 2016 for the 2006 killing of 16-year-old Chanel Petro Nixon. In October 2019, Primus was imprisoned in St. Vincent for 16 months for escaping lawful custody. Then, in December 2020, he was imprisoned again for 24 months for escaping lawful custody a second time, as well as for 3 months for damaging a sheet of plywood.
And they never did anything about getting a DNA.
And I will be here on the 24th of September.
For the sentence?
Yes, I will.
Yeah, because they accepted because the judge was biased.
Ever screamed for help during the 3.5 months?
No. And if I have to do it again, I will do it all over again.
At Her Majesty's prisons in Kingstown, from which he escaped, Primus has also served prison sentences in New York for first-degree criminal contempt and third-degree burglary. Greaves' secretary, Ronella Bailey, discovered her body in Greaves' office at Bijou Real Estate in the Highway Trading Building in Arnos Vale around 9 a.m. on November 13, 2015. The body was found less than 12 hours after a woman, speaking quietly, called the police general line, reporting a break-in at her office in the building. The woman then began to scream, and the call abruptly ended. Detectives responded but found no signs of forced entry. After questioning people in the area, conducting further investigation, and pursuing a lead, they returned to the building but ultimately left without any breakthroughs. Primus, who was deported from the U.S. in June 2015, did not come to the attention of the police until April 2016.
You have sex. She said that she's so terrified with him. You be so terrified with someone and go and continue a relationship with him.
And when you heard the verdict, how did you feel?
Feel happy. Feel glad.
There's a chance.
You asked all that. I was not allowed to ask any question about that.
Able to sleep at night when it was dark?
Sometimes.
Not always?
Not always. That he's the one that did the actual stabbing. He's the one that used the knife.
At that time, detectives were investigating a report by Vermont resident Moana Hadaway, then 24 years old, that Primus had kept her against her will in his home in Vermont from January 1st to April 15th, 2016. Finally, this serial offender was brought to justice and sentenced to 34 years in prison. Back on April 1st, 2012, in Washtenaw County, Harvey Wentz subjected a boy to torture. During the trial, things didn't go well for him. His testimony was crucial in deciding the outcome of the case.
I just want to say, throughout this year, Your Honor, spiritually, I became a better man. At first, when I came here, I didn't know what to do. I didn't know if I should give up or if I should keep on struggling through this process. I just want to say, through the likeness and guidance of God, I was able just to stand strong and still say that I'm a man. I took care of my since they was kids. I never heard the prosecutor saying that I kid. He's saying that this is an example to set on an innocent man, even though I got found guilty by a jury. But that don't mean I did it. They could have found me guilty of them pictures. They could have found me guilty of just, I don't know, but it wouldn't, my testimony is real. I mean, I said some things that wasn't accurate in the interrogation room, but I ain't mean to lie. I meant to tell the truth. When he came and asked me, did I want to ask questions, my flesh told me don't go do it, because I know what he wanted. He just seen me from where I'm from. He just wanted me to come before he could lock me up. But my heart told me to go because I ain't got nothing to hide. You know, I'm just asking you to give me leniency and mercy, because I'm not a bad man. I'm a good person. I mean, I understand I have a criminal record of home invasion, but that was just one time. After I did that, after my mom set me straight, I got 2 jobs. I had I went to school. I wasn't doing nothing bad. I never did anything to hurt nobody. I take responsibility of leaving him. They'll hunt me every day. But the fact to say that, why would I do that? I had no reason to. But the thing I'm just asking you, Your Honor, is just for my family, for they won't leave her, even though 22 years is a lot. Well, I don't know how this 30 years is too much for somebody that ain't a bad person. When I've been in jail a whole year, you can't ask one officer, have I had a problem with him? I haven't, even though I came here on something that wasn't true through a detective. But I'm not a disrespectful man. I respect my elders. I respect people. And I just pray and ask God that He lead you the leniency and the grace to give me something that I can stand. And I love my family. And I want to let my family know. Stay strong, because I'm going to stay strong. But I don't know how long it's going to last. I love y'all. And to Julian, I'm sorry that I left you alone. If he's not here, spiritually, I know he can feel me. If you walk through this door right now and to tell you that I didn't do this to him, that I only left him alone, then what would happen? Will I still get sentenced? And first degree, after they come out of the kid's mouth for some couple of years later on, when he tell the truth, then what can Mr. Hallam say? Can he say this because I got found guilty by 12 people that don't even know me? Don't know nothing about me. They only knew what the tape said. They don't know me. They don't know the boy that cries inside the man. I want to say, just have mercy and grace on me. Lindsay O'Brien.
At times, criminals may try to convince others of their innocence by shouting and yelling, hoping to distract from their actions and avoid responsibility for their crimes.
Prosecutor, what you want to prosecute me for, man? I'm a good man. I ain't never do nothing, man. I ain't do shit to that man. What y'all prosecute me for, man? What y'all prosecute me for? What I do? I ain't do nothing. No, this ain't right. This is not right, man. This ain't right. Y'all got me for myself.
I'm the pastor. Calm down. Calm down. This I'm your pastor. Calm down. I'm your pastor. Calm down. I'm your pastor. Calm down. Calm down. Okay, this isn't gonna help now. Okay. Y'all calm down. Have a seat. It's not going to help. Sit down and you He's still having fights. Okay.
The judge, who was fully aware of all the facts of the case, delivered a fair and appropriate sentence.
As I was saying, I was imposing sentence on count 2, first degree. It is the sentence of this court that you serve 120 months to 15 years with Michigan Department of Corrections, credit for 393 days, concurrent with count 1. As to count 3, assaulting, resisting, obstructing a police officer, 316 days incarceration in the Washtenaw County Jail with credit for 316 days served. You must pay $68 state costs and crime victim assessment in the amount of $130. There is a form that Mr. Fifelski is going to be handing you. You're entitled to file an application, you're entitled to file to appeal to the Court of Appeals your conviction and sentence. If you're financially not able to retain a lawyer, you may request appointment of a lawyer to represent you on appeal. The request for an attorney must be made within 42 days of sentencing.
Your Honor, and I am handing that form to Mr. Wentz. Do you acknowledge receipt of that form, the appeal form?
Yes.
Okay, here you go. Thank you,
I
Your Honor.
believe that concludes the sentencing. Count 2 did not have any costs. Okay. So there are really 2 different victims, as I see it, the police officer and the so I think technically we could charge the crime victim assessment on each of those. Okay. So I'm going to keep that as is. Okay? Anything further on that file?
Nothing on this, Your Honor. Thank you.
Okay, so then we need to turn to the other case.
Meet Adam Montgomery, the man who tragically took the life of his own daughter, Harmony. The family was headed to a fast food restaurant when Adam suddenly lashed out at Harmony, repeatedly assaulting her because she was having accidents in the car. Now, Adam is in court awaiting his sentencing.
Of the life that she was to lead, you stole from your sons a sister, you took a daughter from her mother. You were convicted of reckless second-degree. Reckless in this context does not mean something that was an accident. It is defined under law as something that manifests the extreme indifference to a human life. Your extreme indifference to the value of human life is seen in so many of your actions in this case. In 2019, you beat Harmony. In the words of your uncle, her eye was fully black and blue like a raccoon eye, is what he said. Your words, when asked, were, quote, I bashed her around the effing house. And then you hid her from the view of others, and you kept her from those that came to help her. Your criminal history similarly reflects your extreme indifference to the value of human life. Your actions having taken both a physical and emotional toll on so many. In 2008, you were convicted of criminal threatening after pointing a In 2010, you were convicted of armed robbery and assault and battery with a dangerous in a home invasion incident in which it was reported that you held up a woman at gunpoint, terrorizing her to the point that she lost control of her bodily functions. In 2009, you were convicted of first-degree assault for shooting another person. In 2014, you were convicted of assault and battery with a dangerous and larceny in a case in which it was reported that you shot a man in the face. In 2019, you were convicted of 2 counts of armed career criminal, 2 counts of theft, and 2 counts of receiving stolen property, all of the charges stemming from the thefts of firearms, exchanges of for drugs and money. The court has to consider 3 primary goals of sentencing: punishment, deterrence, and rehabilitation. The focus today is on your convictions in this case: second-degree murder, falsifying physical evidence, witness tampering, abuse of a corpse, and second-degree assault. But the prior convictions are important, and they're important as well as each of them reflects not just your extensive criminal conduct, but each of them represents an opportunity after sentencing for you to have changed the trajectory of your life, to change how you were treating other people. But you were either unwilling or unable to do so. And as a result, at this point, the court has the responsibility to impose a sentence that not only punishes you harshly for the crimes that you have committed, but considers deterrence, that is, how to keep you from hurting others. In light of the egregious nature of the crimes of which you have been convicted in this case, and taking into consideration your extremely violent criminal history, the court finds the only way to do this is to keep you off the streets. To the extent you seek to rehabilitate yourself, that will have to happen behind the prison walls. Harmony was an innocent 5-year-old girl. You treated her in the worst of possible ways, in both her life and in her death. Therefore, the court sentences you as follows. On charge ID 2027112C, the charge of second-degree, you are sentenced to the New Hampshire State Prison for not more than life nor less than 45 years. That sentence is stand committed. That sentence is consecutive. All of these sentences, I should say now, are consecutive to each other, as well as consecutive to docket 216-2022 CR 577, which are the sentences that you're currently serving. Additionally, you're to participate meaningfully and complete any counseling, treatment, or education programs as directed by the correctional authority or probation, parole. Law enforcement agencies may return evidence to its rightful owner. You are ordered to be of good conduct and comply with all the terms of this sentence. This is also consecutive to the second-degree assault charge in the docket ending in 20. That is charge ID 1937947C. Do you have any questions about that sentence?
Nope.
On charge ID 2027113C, falsifying physical evidence, on this charge, you are sentenced to New Hampshire State Prison for not more than 7 years nor 3.5 years. This sentence is stand committed, consecutive to all of the other charges that I'm about to read you, as well as consecutive to the second-degree assault charge and the docket ending in 20 and the sentences that you are presently serving. You do have the obligation, as with the other sentences, to meaningfully participate in programming as directed by the correctional authority or probation, parole. You're ordered to be of good conduct and comply with all the terms of that sentence. On the charge of tampering with witnesses and informants, you are sentenced to the New Hampshire State Prison for not more than 7 years nor less than 3.5 years. Again, this sentence is consecutive to the additional sentences that I've read to you that I'm reading to you in this case, as well as docket ending in 20 and the sentences that you are presently serving. You have the same obligations for participation in programming, and law enforcement may return evidence to its rightful owner. On the abuse of corpse charge, on this charge, you are sentenced to the maximum penalty of 12 months at the House of Correction. All of this sentence is suspended for 25 years. If it were to be imposed, it would be consecutive to the sentences that I read to you. And on this charge, you will also have the provision of a no contact order, and that is no contact with the Sorey family, the Miller family, and the Rafferty family. That sentence is also consecutive were it to be imposed to all of the other sentences in this case and the sentence you're currently serving. On the second degree assault charge ID 1937947C, you are sentenced to New Hampshire State Prison for not more than 8 years nor less than 4 years. This sentence is consecutive to the sentences in docket 216-2022 CR 2372. This is charge ID 1937947C. On this charge, you have the additional requirement, as you have in the other cases, to meaningfully participate in programming. Law enforcement agencies may return evidence to its rightful owner, and you're obligated to be of good behavior and comply with all the terms of the sentence. Do you have any question about those sentences?
On July 31st, 2021, in Lincoln Park, Tobias Katron, known for his knack for getting away, appeared in court after being apprehended in a young woman's bedroom. Despite facing the repercussions, he maintained his characteristic demeanor. The judge carefully examined every aspect before delivering the sentence.
I also believe that Mr. Kazak did send you a copy of the motion, correct?
You did.
All right, and so are the people prepared to proceed on the motion?
Yes, Your Honor, we are.
Okay, Mr. Taylor, are you ready? Are you prepared to proceed on the motion?
I am.
All right, and the court will note, based upon the emergency motion filing and your late appointment, the court will still allow you to permit you to make oral argument without submitting a response, a written response, okay? All right, and so Mr. Kazak, you may proceed.
Yes, Your Honor, the people are requesting that the defendant's bond be increased to substantial cash bond. At the time of the defendant's arraignment, the defendant was given a $5,000 personal bond. People believe that the court, that the arraignment magistrate did not properly consider the various factors which the court should consider when setting a personal bond, including the defendant's criminal history, likelihood of appearance, and safety of the community. In this case, Your Honor, we have an individual who was just released from on parole for another felony case, who has a status of fourth-degree habitual offender, and who, right after being released, takes a stolen car and drives 90 miles an hour, fleeing from the police into the city of Detroit, not only endangering the lives of the public, but also posing a severe risk to the officers who are following him. People believe that there at least needs to be some cash bond, not only ensure the defendant appears, to ensure that the type of behavior which people believe the evidence shows committed in this case will not be perpetrated while he's on bond on the current case. I certainly think a $5,000 personal bond, or the defendant there's nothing to force the defendant to appear in person for his future court date is substantially, it's just not appropriate in this case, and that a substantial cash bond needs to be imposed for the defendant. We leave the amount of discretion to the court, Your Honor, but I don't believe a personal bond is appropriate, given all the factors which the court, under the court rules, should consider when setting the bond.
All right, thank you very much. And Mr. Taylor.
Your Honor,
I'm not going to try to make excuses for my client, but actually what he did, he harmed himself more than anybody else. He has a splinter spleen, and I believe his pelvis is broken too, and he has a tether already, and he really can't even get around good, and he's going to therapy. So I think if he's remanded, he's not going to get proper help. So I think a minimum bond would be proper, and he has a tether already.
Is the tether as a result of his MDOC parole, or is it as a result of his bond?
In MDOC parole.
Okay.
He's under house arrest,
He's on house arrest.
It just indicated that to me, yes.
And so what, are there specific terms regarding your house arrest? Are you permitted to leave the home for work?
Yeah, I could leave the home for work, but at this time I can't walk because I have my hip is fractured in my pelvis. So I can't walk. I got physical therapy appointments coming up.
Okay, hold on, sir. My question was, are you permitted to leave your home for work?
Yeah, only for work.
Okay, so is that yes?
Yes, ma'am. Yes,
okay,
ma'am.
So where do you work?
At Packwright.
And so what are your hours?
I had just started. I was working midnight shift, 10 to 6.
That's 10 p.m. to 6 a.m.?
Yes, ma'am.
What days of the week, sir?
I had just started, so that was my first day that I got into this incident. So I don't really know.
So your first day was October 21st?
Yes, ma'am. So as of right now, I can't go back to work because I can't lift more than 60 pounds because I can't walk. You know what I mean?
Okay, and so where's Packwright located?
It's in E-course.
And yet this incident alleges that you were in the area of 7th and Cherry in the city of Wyandotte on the same time that you should have been working.
Yes, ma'am.
And so you were not at work that day, even though your tether allows for you to be out for work purposes, you do not appear to have been at work that day.
Your Honor, I was never on the tether until after this incident that we're here for right now. For this incident, they put me on the MDOC tether, house arrest, and I gotta go to treatment, physical treatment, physical therapy, and also like counseling.
Okay, so you were on parole.
Yes, ma'am.
You're paroled in September.
Yes, ma'am.
And
some people become so familiar with criminal behavior that it feels like second nature. They might describe their actions in a way that tones down the severity of their actions.
What city are you living in?
Lincoln Park, Michigan.
Is it the address on file, or are you staying somewhere else?
Staying on file because I have to be there on my house arrest, so I violate instantly. So I'm automatically being monitored at 24/7, and I can't even leave because I can't walk.
Well, you can walk with the assistance of a walker, right?
Yeah.
Yes?
And proper medication, which they won't give me in any local facility.
And how do you know that, sir?
Because when they tried to take me there last time, they said they wouldn't give it to me.
Who's they? When they tried to take me there last time, they wouldn't give it to me.
Wyandotte tried to take me to MDOC to hold me, and that's why they put me on the tethers. I can't walk, I can't have my walker. And I gotta do my physical therapy appointments. I'm not gonna heal right. I got 3 months of physical therapy. And I gotta get my stitches taken out, which are currently infected right now. I can show you. And I just left the hospital yesterday for that. I got papers to prove a prescription for the infection. I understand I made a mistake, but I also was doing good too. But there's no excuse. I did, I'm just grateful I didn't hurt nobody. And I just asked, at least let me be able to do my doctor's appointments. I came here today, I'm not no flavorist. I'm here, I'm on house arrest, I'm on tether, I'm not going nowhere. So I just recommend you keep the body the same. You see I'm not running, trying to change my life this time.
And sir, what is the curfew that you have to abide by?
I can only come
prior to your tether, what is the curfew?
Oh, I come out from like 8 in the morning to 11 at night.
So 8 a.m. to 11 p.m. was your curfew prior to this incident?
Yes, ma'am.
And this incident is alleged to have occurred at around after 3 o'clock in the morning, correct?
Yes, ma'am.
So outside of your curfew time, correct?
Yes, ma'am.
All right, anything else, Mr. Kazak?
No, Your Honor. Again, I think the court's fully apprised of the fact situation. Again, that we would just our motion for respond.
All right, anything else, Mr. Taylor?
Only does the court take all the matters in consideration? Thank you.
All right, thank you. And pursuant to MCR 6.106H2A, and prior to the arraignment on the information, this court may modify a prior release decision on motion of a party or its own initiative on finding there's substantial reason for doing so. After hearing from Mr. Kazak and hearing from Mr. Taylor and Mr. Katron, the court will indicate the following. In this instant case, the defendant, Tobias Katron, has been charged with fleeing eluding third degree. This charge is a felony charge with an enhanced penalty of up to life imprisonment if convicted, and that's due to the habitual offender fourth offense notice. Mr. Tobias was arraigned by a judicial officer of the 36th District Court, not by a judicial officer of the 27th District Court. The bond that was set on October 23rd was a $5,000 personal bond, and there was not a GPS tether provision, just the standard provisions of appearing in court and not consuming alcohol or any drugs are not prescribed and not leaving the state. This court does not know what factors were taken into consideration at the time the bond was set by the 36th District Court judicial officer. The court will note, however, that in determining pretrial release of a defendant, bond and conditions, judicial officers do have an extremely difficult task of balancing the safety of the public with the accused's constitutional right to pretrial release. Sometimes the judicial officers may not have all the information, as the complete criminal history of the defendant is sometimes not known. In reviewing the criminal history of this defendant, what has been made abundantly clear to this court is that the defendant's current CCH was not completely accurate. For reasons not clear to this court, there are charges as well as convictions that are not appearing on the CCH, but do appear on the Third Circuit Court Register of Actions and the 25th District Court's Register of Actions. The court will also note that back to 2015, when the defendant would have been around 19 years old, the defendant has had 25 criminal charges, of which 22 are felony charges. Of those felony charges, the following have been convictions. 2016, 3 counts of assault with a dangerous weapon, also known as felonious assault. 2017, assaulting, resisting, obstructing an officer. Another charge and conviction of 2017 of assaulting, resisting, obstructing a police officer. In 2018, another conviction of assaulting, resisting, obstructing a police officer, and possession of by a felon. And I believe these are the convictions that the defendant is on parole for. And then in 2019, additional 3 counts of assaulting, resisting, obstructing a police officer.
Once the judge finds them guilty and delivers the sentence, the criminal sometimes reacts as if the law were just a game to them.
It's all alleged to have occurred during the time when the defendant was supposed to have been home during his curfew as ordered by his parole. This behavior shows a complete and utter disregard for the safety of the public. This behavior shows an utter and complete disregard for the orders of a parole agent as well as additional court orders. Defendant has been unable to comply with the terms of this parole release. The defendant failed to show this court that he's able to abide by this court's conditions. Based upon all of the foregoing factors, hearing arguments by counsel, the legal authority by which this court may act, the court is modifying the current bond. The court finds that a $5,000 personal bond in this matter is woefully inadequate. The court is going to issue a bond in the amount of $250,000 cash or 10%, no surety. In the event bond is posted, you shall not be released on GPS tether, house arrest. Please don't interrupt the record, sir.
I ain't heard that shit. I'll be downtown next week, they drop the bomb.
You're not to possess and consume any alcohol that are not prescribed. You're to comply with all parole supervision orders. And quite frankly, the court's going to indicate a $500,000 cash bond, no 10%, no surety based upon the defendant's behavior here in court. The court will mark your file medical, so you may receive the medical treatment that you need.
Next week.
Anything else? Anything else for the people?
No, thank you very much, Your Honor.
Anything else for the defense?
No, Your Honor.
All right. Now, that's as it relates to the motion hearing. As the probable cause conference that's scheduled for today, also, it's my understanding this matter that the defendant has waived his preliminary, right to preliminary exam. Okay, hold on, we do need the defendant here.
Why you touching on me, bro? I ain't touching you, bro. Quit touching me.
Mr. Katron, please
step over here. We go downtown next week, they go give me a personal money again, fucked up.
Please return to the table so we can complete the probable cause conference.
Tobias. I promise you, when you're not touching me, I'm not gonna allow you.
This is Tobias. No. Yeah, I indicated to Mr. Katron his right to have a preliminary matter hearing on this matter, and at this time we was.
I need him closer to the microphone.
Your Honor, I indicated to Mr. Katron his constitutional right to have a preliminary exam for this matter at this time. We was.
All right, Mr. Katron, you heard what your attorney indicated, correct?
Let's get this over. Send me downtown. I'll be out next week. I waive my preliminary. Let's go.
Sir, I understand you want to get this moving.
You said all the facts,
but I need
negative. You didn't know me be here, medical, nothing.
Stop.
Negative. You just not working with them. Just send me downtown.
Sir, I need to make sure we have some stuff on the record. Okay. So please stop. Stop. That's fantastic.
I've been here before. I waited preliminary.
All right. So I just want to make sure that you do understand you have the right to have an attorney. You've had one appointed to you today, correct?
So I gotta understand all.
Do you understand that, sir?
And I waiver. I send it to myself so I get time to come home.
So you have the right also to preliminary examination, or it must be shown a crime was committed and a probable cause exists to charge you with that crime. You understand that?
Yes, Your Honor.
All right. Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination today?
No, Your Honor.
You also understand that by waiving your right to your preliminary examination, you understand that you'll be bound over to circuit court on the charges and the complaint and warrant.
Yes, Your Honor.
All right. The court will indicate that examination has been waived. The defendant is bound over to circuit court. You are to appear in circuit court on November 10th at 9 a.m.
That's when y'all see me next, around the 10th. Find out I'm free.
Anything else for the people?
No, thank you very much, Your Honor.
Anything else, Mr. Taylor?
No, Your Honor.
All right.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.